We've all got those neighborhood rules. Some of them make perfect sense, and some, well, they can feel a little much. But what happens when your neighborhood passes a rule that you think is completely unfair and you decide you're going to fight it? Today, we are diving into a dispute that seems simple. It's just about parking spots, but it went all the way to a legal hearing. And trust me, it tells us a whole lot about the true power of a homeowners association. No, really, just picture it for a second. Suddenly, you can't park in front of your own house. Your friends and family have nowhere to park when they visit. It would be a huge headache, right? Well, for one homeowner, this wasn't just some hypothetical. That's exactly what happened to a guy named William P, and he decided he was not going to let it slide. So, let's set the stage here. On one side, you have our petitioner, William P. He's just a single homeowner in the Greenlaw Townhouses community. And on the other side, the respondent, the Greenlaw Townhouses Homeowners Association, the HOA, the group in charge of making and enforcing the rules for his entire neighborhood. It's a classic David versus Goliath setup.
All right, so how did Mr. Lee plan to take on the HOA? Well, his case was built on a really smart and powerful argument. He didn't just stand up and say, hey, this new rule is inconvenient. No, he argued that the HOA had actually broken its own rules, its own foundational documents to get this ban passed.
Now, to really get what he was arguing, you gotta understand what CC&Rs are. The easiest way to think about them is like the Constitution for a neighborhood. They are the big, important, foundational rules that everybody agrees to when they buy a house there. And the key thing is, they're not supposed to be easy to change. So, Mr. Lee's strategy was to take the court back in time, to the community's original Constitution. He pointed to Amendment Number 1. And what did it say? It banned parking, but only in designated fire lanes. Totally reasonable, right? For safety. Then he presented Amendment Number 2. Again, super specific. No parking on the streets, but only when the snowplows need to get through, which makes perfect sense for a place like Flagstaff, Arizona. So far, the rules are pretty limited, and they're all based on specific situations. And the third piece of his puzzle was Amendment Number 3, which was all about abandoned cars. A car had to sit there for a full 72 hours before it was even considered a problem. So Mr. Lee's point was crystal clear. The community's own foundational rules, the CC&Rs, only banned parking in these 3 very specific cases. That's it. But he wasn't done there. He also went after how the HOA pushed this new rule through. He argued they broke their own procedures. He said the notice came through email when the bylaws required good old postal mail. He said the email itself was confusing and didn't clearly state that a major rule was changing. And then he even suggested that this whole thing might have been done just to make one specific board member happy. Okay, so that's the homeowner's case. It sounds pretty strong, right? Now let's flip the script. How in the world did the Greenlaw HOA defend putting in place such a drastic, all-out ban on street parking? Well, their argument was actually incredibly simple.
And this right here is the heart of the whole conflict. The HOA basically ignored the old amendments and pointed to a newer document, their 2018 Rules and Regulations. And Section 8 of that document couldn't be clearer. It says, parking is not allowed on any association street or alleyway at any time. Period. No exceptions for snow, no 72-hour grace period, just a total ban.
So the HOA went down the list and countered every single one of Mr. Lee's points. They said, look, those 2018 rules and regulations, that's the new law of the land. That's the document that matters now. They claimed they didn't have to use postal mail. They showed proof that Mr. Lee did, in fact, get the email with the new rules. And here's the kicker. They argued the new rule doesn't violate the old CC&Rs. It just supersedes them. It's an update. So this is a classic showdown, right? You've got the homeowner on one side, holding up the community's original Constitution. And on the other side, you've got the HOA, waiving this newer, much tougher set of rules. An administrative law judge had to step in and figure out who was right. And when the decision came down, it was fast and it was final. Mr. Lee's petition was denied. The homeowner who fought to keep street parking for himself and his neighbors lost. So he lost. But the real question here, the one that we all can learn from, is why? Why did the judge side with the HOA? Especially when Mr. Lee's arguments, based on the original founding documents, seem to make so much sense. This is the really important part. The answer really comes down to this legal phrase, preponderance of the evidence. Now, this isn't like a criminal case where you have to prove something beyond a reasonable doubt. In a civil case like this, the person bringing the complaint, in this case Mr. Lee, just has to show that their side of the story is more likely true than not. It's about whose evidence has more weight, even if it's just by a little bit.
And here's basically how the judge's logic went. First, the judge looked at the evidence and agreed with the HOA. Those 2018 rules and regulations were the valid controlling rules for the community. Second, the judge decided that the new total ban didn't actually contradict the older specific rules in a legal sense. And because of those two things, the conclusion was that Mr. Lee just didn't have enough evidence to tip the scales. He failed to meet that burden of proof.
So let's really drill down on this for a second. When we look at exactly how the judge shot down each of Mr. Lee's main arguments, the picture of why he lost becomes perfectly clear. Mr. Lee claimed the new 2018 rules were invalid because of how they were sent out. The judge said, nope, they're valid and they are in charge. He claimed the new ban violated the old CC&Rs. The judge said, no, it doesn't. He even claimed the HOA was the one improperly booting and towing cars, but he couldn't provide any solid evidence to prove it. At every major turn, his arguments just didn't have the proof to back them up. And that brings us to the single biggest lesson from this whole affair. And this is something every single person living in an HOA needs to hear. An association's current rules and regulations, which are often much easier to amend than the big CC&Rs, can be used to create brand new, sweeping restrictions that can completely override older, more specific rules you thought were set in stone. So when you put it all together, this whole case is a huge wake-up call. It's so easy to just assume you know the rules where you live, but these documents can and do change. So it leaves us with one final, really critical question to think about. How well do you really know the rules in your community's latest rulebook?